Good afternoon, everyone. My name is Yanine. I am a second-year law student here at UC Berkeley School of Law. I wanted to welcome you to our program for No Torture Week. I am part of the Bold Alliance to Abolish Torture. We are a coalition of student organizations and individuals at Berkeley Law that work to restore respect for human rights and the prohibition against torture. Thank you for coming to today's panel.
Thank you.
Thank you. Our speakers today are Jason Leopold, who is the Deputy Managing Editor of Truthout, and Jeffrey Kaye, who is a contributor to Truthout, as well as a psychologist in San Francisco. We're very fortunate to have them both here today because just yesterday, they released an article describing their investigative report on a little-known directive issued in March 2002 by the former Deputy Secretary of Defense, Paul Wolfowitz, which weakened a decades-old ban or protections against human subject research and experimentation conducted by the Department of Defense. Thank you for being here.
Thank you. Hi, everyone. Thanks for having Jeff and me here to speak about our article that we spent 7 months researching this. And first, let me just say that I want to keep this sort of our discussion somewhat short because I feel that these programs are best served with questions and engaging with the audience. But just as by way of a little background, I work for Truthout.org. It's an online nonprofit web publication, and for me, it's fortunate because it gives me the opportunity to spend the time on stories such as this. And Jeff and I had spent the past 7 months investigating this, and I have to say that this is was, in my 15-year career as a journalist, the most challenging and difficult story that I've ever undertaken. And the reason for that is it's highly technical, highly classified, and got into an area that most people just refuse to discuss. And back in March or April, I forget at this point, we were pointed to a little-known directive issued by Paul Wolfowitz on March 25th, 2002. And we've handed out the story to you guys if you want to take a look at it. But it's Wolfowitz directive gave legal cover to detainee experimentation program. Now, most people, when they're, when we're discussing the issues of torture, particularly the Bush administration's policy of torture, is largely focused on the CIA. And we've certainly seen plenty of documents and heard many discussions about the CIA's enhanced interrogation program. But not, to my satisfaction, there has not been enough coverage of the Department of Defense's role in all of this. And going beyond what the actual torture program was, what we discovered is that it was largely a program of human experimentation and research. And if I just may add that Jeffrey Kaye has been far ahead of any single journalist out there over the past 5 years in digging into the issue of experimentation. And what he has done that has certainly educated me has dug into the documents that have been released and picked out and pulled out pieces of information that really show that what we have done to detainees, both in CIA custody and in the custody of the Department of Defense, has been a matter of experimentation and research. And for a wide range of reasons, which I'll let Jeff discuss. But when we got this, when we were tipped off or pointed into the direction of this directive, for me, it just, you would not be able to understand it or understand what the implications are if it were just handed to you. And in fact, you wouldn't even realize that that it was of any importance unless you started really looking at the history behind it. And like I said, it was issued on March 25th, 2002. Okay, that's an important date for a number of reasons. One, it was 3 days before the CIA captured the first high-value detainee named Abu Zubaydah, who was in the custody of the CIA before he was handed over to the Department of Defense some years later. And Jane Mayer, in her book, The Dark Side, certainly has articulated how his torture was an experiment. In fact, she has a chapter called The Experiment. And then this directive was also issued about 1 month or so after George Bush issued an action order suspending Geneva Convention protections for individuals captured in the War on Terror. That's part of the reason they were called detainees. They were not prisoners, they were detainees. And Donald Rumsfeld made sure everyone knew that during a news conference in January of 2002. So, in this directive, it actually states that the protections against human experimentation for prisoners of war were in place, but there was no protections for those that would be otherwise referred to as unlawful enemy combatants. And basically, this directive sort of left them vulnerable. To me, it sort of suggested that they weren't even people. They were just nothing. Well, another class of people being redefined. And the directive actually implemented a legislation that was quietly passed in December of 2001 as part of the Defense Authorization Act, known as 10 U.S.C. 980. And this is a law that was put into place. It has not been touched. Jeff can certainly discuss it. It was not touched for 3 decades. And it was, in 1972, it was passed basically prohibiting experimentation and requiring by the military, specifically for the military. In fact, it's the law that governs how the federal funds are used for Department of Defense research. And in 2001, it came up where the Department of Defense, the House Armed Services Committee and the Department of Defense wanted to tweak this law and basically allow the Secretary of Defense to issue a waiver on what is referred to as informed consent. The law basically said that in any sort of experimentation program or research that the individual has to give their informed consent in order for the research to take place. And if that was unable to happen, a legal representative could do that. This law was changed, giving the Secretary of the Defense authority to waive the informed consent rules. And that was quietly passed as part of the Defense Authorization Act in December of 2001. That's also another key moment in the torture story, because that is when, according to the Senate Armed Services Committee report, when the Pentagon had contacted the Joint Personnel Recovery Agency, JPRA, for information on interrogation and SEER tactics. SEER, survival, evasion, resistance, escape, which is was, as we know, reverse engineered to basically allow these torture tactics to take place, use them against detainees. And in fact, one of the individuals who's quoted in our story, Captain Michael Kearns, who is a SEER instructor, is actually here. He's right over here. He's someone who also happened to, and by the way, I must say, I've spoken to several people and I say that Michael Kearns is a SEER instructor, and there's a little bit of fear there. Michael Kearns did not invent the torture program. And SERE instructors, by and large, you know, the same way that John Yoo twisted the law to allow the torture program, or to legalize the torture program, that's what they did with programs like SERE. And you know, I would encourage people to, you know, take some time to speak to Captain Kearns to get a little bit more information on that. But in December of 2001, the Pentagon General Counsel William Haines contacted JPRA. They wanted some information on these interrogation procedures. And again, what we were told during the course of our investigation was that this was part of a highly classified special access program funded through the Pentagon's black budget that involved deception detection and measuring levels of stress. And I think Jeff can speak very eloquently on the medical procedures involved in order to obtain that research, what went into it. And it really, at that point, turned into, you know, a program of research and experimentation, and the you know, the pieces were in place to foster that, and Wolfowitz's directive helped implement the policy. So, you know, as you could tell just by the way I'm describing this is incredibly technical. It's highly complex, and it presented for me and Jeff a major challenge in being able to articulate the story into a narrative so people would understand that the torture program was not just about waterboarding, but also involved human experimentation and research. And this investigative report that we published yesterday, I believe, certainly makes that case, and it makes a very strong case to show that this was, in fact, what took place. And, you know, just speaking of the medical aspects of this, I'm not sure how many people are aware of this, and I hope that everyone is, but when John Yoo wrote that torture memo, he relied upon an obscure medical benefits statute, a health benefits statute that basically, that's how he arrived at the definition of what severe pain is. So it's sort of ironic, I don't know, in a sick, twisted way, that this obscure statute is what became the basis for, you know, what severe pain is, organ failure, you know, pain rising to the level of organ failure or death. So during the course of our investigation, you know, we spoke to, in addition to Captain Kearns, some high-level officials in the Defense Intelligence Agency, and basically these individuals told us that this Wolfowitz directive was it was the legal document. If I can just find the quote here, it was the legal document that was used to support this special access program involving research and experimentation. And, you know, we also go into a specific case, the case of Muhammad al-Qahtani, who was one of the, I don't even know how many 20th hijackers or 21st hijackers that the Bush administration had claimed, you know, was involved in 9/11, and how his torture was basically an experimentation and a research program.